Hello, my name is Catherine Renfro Piehut, and today I'm going to give a presentation on adoption law. Adoption law revolves around the legal action that is required to voluntarily assume the responsibilities for the parenting of an individual. Because the area of adoption law is very expansive and dynamic, it's comprised of various contrasting details on a case-by-case basis. There are many different requirements associated with the distinct and individual adoption types. We have international adoptions, domestic adoptions, and foster care adoptions. Currently, there is no nationwide standard for adoption, so the states put forth the laws for us to follow when approaching the adoption process. As you can imagine, there are contrasting rules and requirements for the different types of adoptions. International adoptions consist of the most intricate and demanding adoption processes. In the state of Arkansas, thorough background checks, long-term home studies, and references are required for the protection of adoptees. Recognition of a foreign adoption decree is also required in Arkansas, meaning that when an international adoption ensues, the decree is then treated as uncompromising, as if it were promulgated by the state. On the other hand, Arkansas foster care is regulated through the Arkansas Division of Children and Family Services, under the Department of Human Services. Currently, there is no fee to foster in the state of Arkansas. However, if the aim of fostering the individual is to subsequently adopt, fostering fees will be charged during the household study and assessment. If necessary and proven essential, adoption subsidies may be required by foster or adoptive families. The Arkansas Division of Children must follow all statutes put forth by the state when developing an individual's license to either foster or adopt. Lastly, we have domestic adoptions. These types of adoptions are done through an adoption agency or directly with the birth mother. While the agreement between the agency or birth mother may vary, it is still required to adhere to all state laws. During domestic adoptions, it is common for adoption agencies or birth mothers to have specific preferences such as age, marital status, the ability to become pregnant, and even personal views. One of the most important aspects of adoption law is consent, and since any single adult or two married individuals can adopt in the state of Arkansas, as well as any individual can be adopted in the state of Arkansas, it is necessary to know when consent is needed and when it is irreversible. Consent is a very significant aspect of any adoption and must be clearly understood in every situation. Adopting a child in the state of Arkansas requires consent from that child past the age of 10, unless the child is in a compromised living situation. If a divorcee remarries, and there are children from a previous marriage, the new spouse may adopt children from the previous marriage with the children's consent in the state of Arkansas. While in a domestic adoption, consent can be offered immediately after the birth of a child and is also deemed irreversible 10 days post-birth or after the legal adoption has been officially endorsed in the state. Another very important aspect of adoption law is custody. I'm going to speak about two cases to illustrate the importance of establishing custody of adoptive or biological children. The reason why the petitioner and respondent's names are not used is to protect the child in this case. Yet, since this is a well-known and highly publicized case, we now know that the child referred to as baby girl is Veronica. The case of adoptive couple versus baby girl, aka Veronica, was brought to the Supreme Court to decide if a parent who belonged to the Cherokee Nation may attempt to impede upon an adoption without acquired custody while utilizing the Indian Child Welfare Act, also known as the ICWA, as well as how was the term parent established under the ICWA when referring to a non-custodial parent. When Veronica's mother became pregnant, she asked the biological father if he would relinquish his rights to her, and he agreed. After, she placed Veronica for adoption. The legal action required for this adoption began and was then halted once the ICWA recognized the biological father as a member of the Cherokee Nation. Veronica was then placed in the custody of her biological father for 2 years before trial was moved to the Supreme Court, where it was then ruled that Veronica belonged with the adoptive couple. Similarly, there is the case of Michael H. versus Gerald D., in which Michael H. attempted to claim custody and paternity of a child from an affair 2 years after the birth of the child. The Supreme Court ruled in this case that paternity cannot be challenged 2 years after the birth of a child. A potentially biological father does not have the right to establish paternity after it has been presumed that Gerald D. was the father of Victoria D., the child in question. Establishing custody is so important in order to avoid confusion for these growing children who do not understand what is going on. Another Arkansas law states that non-Arkansas residents may adopt a child from Arkansas. This type of adoption is very delicate because of full faith and credit, by reason of enforcement of the adoption thereafter in other states. Article 4, Section 1 of the U.S. Constitution states that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. A large number of state representatives have not been fond of the full faith and credit clause, and issues have emerged from same-sex couples attempting to initiate an adoption. For example, the case of VL versus EL. VL and EL, a same-sex lesbian couple, parented 3 children together whom EL was the biological mother of. VL also wanted to claim the children and filed to adopt them in a Georgia state court. The adoption was granted, but later VL and EL ended their relationship. VL then asked an Alabama state court for either custody or visitation and to respect the adoption claim filed in Georgia. The state court of Alabama rejected VL's claim to the children due to the lack of subject matter jurisdiction. Not acknowledging the full faith and credit clause, this trial was then brought to the Supreme Court, where it was decided that the full faith and credit clause of the Constitution must be upheld in the Alabama state courts. It was also recognized by the courts that the only ground for denying full faith and credit would be if the courts did not have subject matter jurisdiction, which they did, as well as stating that since adoptions shall be decided by state law, the judgment decided in Georgia should be recognized by the other states. There is one last case with a similar ruling I would like to mention before I conclude my presentation. This ruling occurred when 2 same-sex married couples attempted to acquire both of their names on their children's birth certificates. Tara and Marissa Pavin, as well as Leigh and Jana Jacobs, both gave birth to children in the state of Arkansas in 2015. Both same-sex married couples filed the proper paperwork in order to both be recorded as parents on each birth certificate. Arkansas Code 2018-401, as put forth by the Arkansas Department of Health, states that birth certificates of a child from a same-sex marriage may only contain the birth mother's name. The adoption of children into families of same-sex marriage have not yet fully been supported, proving difficult for couples in these marriages to adopt. It seems at times that state representatives and policymakers have been creating unnecessary endeavors like the Arkansas Code in this case. Both the Due Process and Equal Protection Clause under Obergefell v. Hodges have been violated due to the discrimination of same-sex couples. This case assures the right to marry as a fundamental liberty regardless of sexual orientation, disallowing states to deny same-sex couples the same marriage rights as opposite-sex couples. Due to this decision, it is therefore unconstitutional to deny both of these couples' names on a birth certificate. It is a state rule in Arkansas to record the birth mother's spouse even if non-biological, thus directly violating the rulings in Obergefell v. Hodges. Being stripped of the right to be recorded on their child's birth certificate presents both of these families with complications related to proof of family. The Supreme Court ruled that the Arkansas state law, derived from Arkansas Code 2018-401, is unconstitutional and in violation of the Equal Protection Clause and Due Process Clause. Same-sex married couples should not lack the benefits that opposite-sex married couples have. As I'm sure you can tell, adoption law is very intricate and extremely state-specific, and it can be a very, very complex process. But I think that adoption law is a really interesting area, and I'm really glad that I got the chance to research this. Thank you.